Welcome back to this final segment of this public law session in relation to public order law and, of course, state security. We spent the first two segments looking at public order law. We started the last segment looking at state security. We're completing this now. And what we're looking at here, where I left off in the last segment, was to consider, for example, situations where you're looking at issues of state security. And the point I made before the break, of course, was that when you look at recent legislation which have really considered the climate of terrorism, which has taken somewhat of a hold since, let's say, 9/11, as it is more widely known, in 2001, 11th of September, and what occurred there. Equally, when you look at 7/7 and what occurred at King's Cross Station in London, we see that there has been this whole push towards legislation which deals with terrorism, counterterrorism, and so on. Now, one of the things that the terrorism legislation makes provisions for are what are called proscribed organizations. So these are organizations where the acts consider are banned organizations, which obviously are looking in the context of terrorism, for example. Now, proscribed organizations are set out under the statute. So in Section 3 of the 2000 Act, we see a provision for prescription of organizations involved in terrorism, and we see that prescription being set out by the Secretary of State, the Home Secretary. Now, prescribed organizations are listed in Schedule 2 to the Act, and an organization is concerned in terrorism if it commits or participates in acts of terrorism, or it prepares for terrorism, or it promotes or encourages terrorism, or is otherwise concerned in terrorism. So if terrorism is your business, it is going to catch you. You will be a proscribed organization. Now, where an organization has been proscribed, that organization may apply to the Home Secretary to have its name removed from Schedule 2. Now, should that application fail, then there can be an appeal to the Proscribed Organizations Appeal Commission, and from there, on a question of law, to, of course, the Court of Appeal or the Court of Session in Scotland or Court of Appeal in Northern Ireland. Now, as it relates to offences relating to membership and support of terrorist organizations, it is a criminal offence to belong to a proscribed organization, so says Section 11. It is also an offence to solicit support, whatever kind, it could be financial or otherwise, for a terrorist organization, and it is also an offence to arrange or assist in arranging meetings in support of the organization, so says Section 12. Now, Section 13 makes it an offence for a person to wear an item of clothing or wear or display articles such as badges or banners that give rise to a reasonable suspicion that he or she is a member or supporter of a proscribed organization. Now, the Act extends jurisdiction to try offences to acts of terrorism by bombing, to actions outside the United Kingdom if such actions would be an offence under UK law. And that is set out in Section 62. Now, seizure of property is also a factor when you look at this area, because cash intended for use, or which is the property of the terrorist organization, may be seized and forfeited under Sections 25 and 26. The police also have powers in relation to these kind of terrorist activities. The police may arrest without warrant a person who is reasonably suspected of being a terrorist. This is Section 42. I want you to think for a moment, which is why I've grouped the public order and civil liberties and the whole state security. Is it that when you look at terrorism legislation, it really has pushed the boundaries as it relates to human rights? Because if the police reasonably suspect, and again, reasonable suspicion has been a bone of contention from, even when you look at PACE, the Police and Criminal Evidence Act 1984, what is reasonable suspicion? Yes, we are told it can't be because somebody looks like a particular way or dresses a particular way or wears particular types of clothing, but sometimes it may very well be on that basis. And so the idea of civil liberties then becomes the important. So when you look at the police arrest powers, they certainly may do so if they reasonably suspect someone of being a terrorist. And the act, of course, specifies the conditions of this detention under Schedule 8 and how long you can keep someone in detention for. Now, you can extend the detention by warrant, and premises also may be searched by warrant under Section 42. Equally, the police may search a suspected terrorist, whether he's under arrest or not, to see if he has any evidence of terrorist activity. Is he carrying a bomb in his pocket, for example? Section 43. Now, when you look at the Anti-Terrorism, Crime and Security Act of 2001, this was passed in very rapid response to the terrorist activities in the USA, and the 2001 Act increased the powers of enforcement agencies as it relates to cooperation in investigations, and it also introduced certain detention without access to a court of law in respect of suspected international terrorists, which meant Article 5 of the ECHR was, of course, suspended. It increased police powers in relation to identification issues. It removed the right to judicial review of detention pending deportation decisions. Now, again, when you look at these powers, they seem to be very far-ranging, far-reaching, wide. They seem onerous. But that said, it can make a situation look like a mockery, but I will urge you as law students, please do not get on the bandwagon of, for example, a newspaper or a newspaper article. Remember, these are journalists. There is a degree of sensationalism. What you need to do as a law student is look at the facts for yourself. See whether the law, as it stands, has been abided, if the persons or the actors have abided by the law. And you can't just look at it from an emotional standpoint, because that is not what law is about. So when we look at the kind of powers of detention which are conferred under the Act, what we see was a successful challenge in the case of AN Secretary of State for the Home Department, where the House of Lords ruled that potentially indefinite detention without trial absolutely violated Article 5, which is a right to liberty, as well as Article 14, the right to non-discrimination in the enjoyment of convention rights, and it granted a declaration of incompatibility. Well, the government's response was to introduce the Prevention of Terrorism Act 2005, which replaced the detention powers with control orders, which have also been subject themselves to legal challenge. I want to bring you to one of the more controversial cases, and one of the ones that is certainly trending by all means in recent times, and that is the case of O against the Secretary of State for the Home Department, aka Abu Qatada. When you look at this case, the case is also called Othman and the UK, but it's still the Abu Qatada case. What we have here is the European Court of Human Rights ruling that it would be a violation of Article 6 of the European Convention on Human Rights and Fundamental Freedoms to deport the applicant to his country of origin, namely Jordan. They said deportation would not, of course, violate his rights under Article 3 and 5. What was the case about then? What we had was this applicant who had arrived in the UK in 1998. He was arrested in 2000, detained under the Anti-Terrorism, Crime and Security Act 2001. And that's the A case I would refer you to. On the repeal of the 2001 Act, he was released on bail and made subject to a control order under the Prevention of Terrorism Act 2005. Now, while his appeal against the controller was still pending, the Secretary of State served him with a notice of intention to deport him. Well, when you look at his own background, in 1999, he had been convicted in absentia in Jordan of conspiracy to cause explosions. Well, during the trial, evidence was given by a witness who alleged that he had been tortured. In proceedings before the UK's Special Immigration Appeals Commission, SIAC, SIAC concluded that if there was a retrial in Jordan, the incriminating evidence would be admitted and that this evidence would be important and may be decisive. The European Court said that there would be a flagrant denial of justice if evidence obtained by torture was admitted in criminal proceedings, and so the applicant had presented concrete and compelling evidence that his co-defendants were tortured in providing the case against him. And they said he had met the burden of proof required of him, and so basically they said the UK, of course, could not deport him on that grounds. If you want a brief chronology in respect to the case, we see that 2002 he's detained without charge, 2005 the law lords banned detention without charge, ordering his release. He was issued with a control order, which is a form of house arrest which restricted his movements. By August 2005 he's detained again pending deportation. In 2007 he loses his appeal at the Special Immigration Appeals Commission. In 2008 the Court of Appeals says the deportation to the regime that tortures him would of course breach his human rights. We then see that he's bailed in that same year, and by 2009 the law lords backed the deportation order, saying the Court of Appeal got it wrong. But by January 2012 the European Court overturns that decision, saying Jordan will not provide a fair trial, and certainly by November of 2012 he wins his appeal at the Special Immigration Appeals Commission and is released on bail. The point, of course, is that when you look at state security, the question was whether or not here they could give sufficient assurances that when he went back to Jordan, his human rights would not be violated. And of course, it means that you have to balance state security against, of course, individual rights and liberties. When you look at state security, one of the areas that is also important is the interception of communication. Until 1985, there was no statutory regime in place. It was assumed that warrants were legitimated under the royal prerogative, and we have the now famous case of Malone and Metropolitan Police Commissioners of 1979, where they challenged the power to intercept telephone calls. The defendant in criminal proceedings argued that the interceptions violated his right to privacy and amounted to trespass to his property. Now, in the local courts, of course, and domestic courts, his arguments failed, but we do see that when he took his case to the European Court of Human Rights, the court said that the UK had indeed violated Malone's rights to privacy and the protection he had under Article 8 of the Convention. It therefore gave birth to the Interception of the Communications Act 1985, which was a direct response to that. That, of course, has been superseded by RIPA, the Regulation of Investigatory Powers Act 2000. RIPA makes it a criminal offense to intentionally and without lawful authority intercept anywhere within the UK any communication being transmitted by the postal service or public telecommunications system. Now, a person is not liable under the Act if there is a warrant for the intercept. Now, you must bear in mind that the statutory provisions are detailed and specific in relation to who may issue a warrant, what is the scope, and what is the duration. If you've got a complaint regarding suspected unlawful interception, you can, of course, bring such a complaint to the commissioner and the tribunal, and they are the ones who consider this. Now, when you look at, for example, state security and official secrets, well, in addition to securing its own territory from subversive threats, the state may also need laws to protect it from consequences of disclosure of sensitive information that could be used by its opponents. And we see the 1911 Official Secrets Act, the 1989 Official Secrets Act. What is it? Well, if you look at the official secrets of 1911 and 1989, we see that the 1911, Section 1 of which is still in force, provides penalties for espionage. Section 2 of the 1911 Act, which is now reformed, provides for penalties. One of the things for you to bear in mind is to look at the persons at whom the Act is aimed. Because when you look at the Act, it does provide specifically for persons and the situations that the Act, where the Act will engage. So when you look at the 1989 Act, in place of the blanket prohibitions against unauthorized disclosure, the 89 Act prohibits disclosure of information under various categories. And so when you look at the act, section 1 says it is an offense for members or former members of the security and intelligence forces to disclose without lawful authority any information, documents, or other articles relating to security or intelligence matters that is or has been in his or her possession. Now, it talks about prohibition and damaging disclosure without lawful authority. And the point, of course, is that there is a defense under Section 1.5 to prove that the accused did not know and had no reasonable cause to believe that the data related to security or intelligence. There is, of course, no defense of disclosure in the public interest. This here, of course, you need to look at Section 2 also has an offense for a crown servant or government contractor to make a damaging disclosure of any information, document, or article relating to defense. And we see that in the context of Section 1 and 2, there are certain situations which are excluded. I would urge you to look at them. Section 3 makes it an offense also to make a damaging disclosure of any information relating to international relations. And again, all of these are set out. It is a piece of legislation which is important, the Official Secrets Act. As I say, look at situations to do with certain types of documents and their disclosure. You need to make sure that you are up to speed with them. That, of course, brings us to the end of state security and certainly the end of this law session. I would certainly urge you to join us for others.